Hello, welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. In this video, you're going to be hearing from Rebecca Palmer, who heads the Marital and Family Law practice at Lowndes, Drosdick, Doster, Kantor Reed. In this third video of the three-part family law series, Rebecca is going to be speaking with you about alimony and child support.
Hi, I'm here to talk to you about some family law issues. If you've seen the other videos, I first talked about parenting, then I talked about equitable distribution. You've also heard me say that it's important to go in that order. You go in the order of the acronym of PEACE: parenting, equitable distribution, alimony, child support, then everything else. And that could be anything from attorney's fees to other issues outstanding in the case. So today I want to address alimony and child support very briefly. First, alimony, which will take a little bit longer. In regard to alimony, the very first step I suggest you take when looking at the statute, it's 61.08, you have to consider what is the actual need and what is the ability to pay. So while looking at alimony, you can't just go in and say, okay, give me this. You have to look at various things in doing that. That's why the financial affidavit, well, there's many reasons why, but that's one of the many reasons why the financial affidavit of the parties is so important. Don't have your client simply do a financial affidavit, handwrite it out, and file it. You need to look at it. It's the first time, most likely, they've done a document like that. And they may be way off on their expenses. They may be way off on their values on the assets and debts that are listed there. And you don't want to exaggerate or undervaluate those type of things. But importantly, as in regard to alimony, you want to look, after you've done all the expenses and looked at the parties' pay, what is either their surplus or their deficit. I'm amazed how many lawyers don't look at that. You got to look at it, because at the end of the day, once you've paid your expenses, do you have the need, i.e. a deficit, or you got money left over, a surplus, ability to pay, or not a need? So when doing that and starting with the most basic ground floor work and looking at alimony, consider the need and ability to pay. Very important. Now, next thing you need to look at is the factors, or are the factors. When looking at the factors, you need to look at the statute. Go through 61.08 sub 2, and then A all the way down through J. Going through those factors, there's various things. In fact, the statute reads, in determining whether to award alimony or maintenance, the court shall first make a specific factual determination as to whether either party has the actual need, as I identified, for alimony or maintenance, and whether the other party has the ability to pay alimony or maintenance. Then it goes from the factors, and that's what you want to look at. That's going to help you. So if you look at the various factors in the statute, I won't go through them all, but they are such things as standard of living, duration of the marriage, age and physical and emotional condition of the parties, financial resources, again looking at, that's why you do equitable distribution, looking at that too, what your design is for that before going to the alimony. But look at all of those factors and trying to determine, should my client pay or should my client receive alimony? After you've looked at the factors and trying to determine, is this an alimony case? Let's say we have one, yes it is. The next step you want to say is, what kind of alimony are we talking about? Well, there's various kinds of alimony that you have to consider in cases once you've looked at those factors and trying to make a decision on that. First of all, one of the things that's commonly looked at is, what is the length of the marriage? That's not the end-all be-all, but it's somewhere to start to make a consideration. If the individuals have been married for a duration of less than 7 years, that is defined as what's called a short-term marriage. By the way, a lot of people think, can't get alimony. That's not true. You can still get alimony, and there's various types that you potentially can get even in a short-term marriage. Maybe not some of the kinds, but there are types of alimony that you should consider one way or the other, whether you're going to defend it or ask for it. Next is a moderate-term marriage. That is a marriage having a duration of greater than 7 years, but less than 17 years. So that's the window for a moderate-term marriage. Again, a definition to help you make a decision and try to gauge what alimony should be. The next is a long-term marriage. Surprise, that's 17 years or greater. That is considered a long-term marriage. And if you have a long-term marriage, that opens up a door for potentially additional kinds of alimony. So let's look at those. Alimony currently is very complicated and very disputed because it is not a formula. Yes, there have been suggestions of formula. Yes, we previously and probably prospectively will have a bill that goes up to our government to make some parameters and more specific factors for alimony. But as we stand here today, or as I stand here today, there is not a specific formula. So you have to look at all these items and try to be realistic in trying to weigh all these things. So the different kinds of alimony. One kind of alimony is called bridge the gap alimony. Bridge the gap alimony is kind of awarded to assist a party from going from a married life to a single life. It's a short time period. It doesn't really exceed more than 2 years. So that's one type, again, you might look in a shorter marriage where someone needs some help, but they maybe perhaps have an education or do have a skill that they're able to proceed forward with a career, but need some help from going from whatever the marriage situation was into a single life. The next kind I want to talk about is called rehabilitative alimony. Rehabilitative alimony is a unique breed, and what it is if someone has a specific plan. For example, let's say one part or the other always wanted to be a nurse, but they didn't finish their education, but they want to. So the other side may offer or agree to or have ordered against them rehabilitative alimony. And with that, you have to have a rehabilitative plan. What that means is if you take these classes, you do this type of education, you take these steps specifically, then you get the money. If you don't do those things, you don't get the rehab money. So it's an actual plan that is only paid if the plan is followed through with. Let's say we're talking about the payor, the person who's going to pay the alimony. Why would they want to do that? The concept is at the end of the road, that person's going to be more self-sufficient potentially. Once they've got their additional degree or new training and whatever that is, or brushing up old skills that they had that they need new training on. So rehabilitative alimony is another type to be considered. The next type I want to talk to you about is durational alimony. Durational alimony is a certain amount of alimony for a certain amount of time, and that time can be different amounts. There, again, is no formula and no specific rules. You'll hear all sorts of things thrown around on how long that duration can be. I've heard as of late, it should not be more than half of the marriage. That's the length. You got a 10-year marriage, you should have 5 years durational. That's not accurate. That's not what the law says. But it is a rule of thumb that some lawyers look at. So be aware that you may hear those type of comments. The next kind of alimony I want to talk to you about is permanent periodic alimony. First, if you start talking about permanent periodic alimony with your client, make sure they understand that that's kind of a misnomer. Don't let them be surprised down the road that the payor comes and says, I'm now retiring. This is a substantial change of circumstances, which is permanent in nature. And as a result of that, I'm going to, in fact, need to retire. So the person might say, wait a minute, you said I was getting permanent alimony, and it's not permanent. So when talking to your clients about permanent alimony, make sure they know that permanent does not necessarily mean permanent. The next type of alimony I'd like to talk to you about is permanent alimony. When looking at permanent alimony, make sure to talk to your clients about what that means. If it's being considered, whether you're the payor or the payee, that the name is kind of a misnomer. What do I mean by that? It may not be permanent. You don't want to get a situation, for example, where a client is awarded permanent periodic alimony and they don't realize that the other side has the opportunity, ultimately, potentially, to retire and cease that alimony. Or, in fact, if your client remarries, if that's what is negotiated, or if it's ordered by the court, it ceases upon remarriage or a substantial financial contributor. So the name is a little misleading, so it's not necessarily permanent, but it is until a triggering event occurs. So the person pays and pays until the other side either remarries or potentially dies, or there's some significant substantial change in circumstance or event that occurs. So that is the type, frankly, if you're representing a payor, they do not want to hear the words permanent periodic alimony. Permanent meaning a long-term, periodic meaning paid in intervals, usually monthly alimony. So that is another type of alimony that could be, in fact, awarded. So let's talk about it. Now we've talked about the factors, we've talked about the kinds of alimony. Let's talk a little bit about how in the world do you determine what alimony should be? Well, one of the things people miss is consider where you are in Florida. Different counties, quite frankly, are more apt to be a little more generous or less generous in alimony. It's just a reality because of the economics of that particular county. So that's something to consider. So kind of know your venue, so to speak. Also know that, like I said, there is no formula. You may hear, oh, alimony is specifically this. As we stand here today, it is not, or again, as I stand here today, there is not a specific formula. That said, there are some guidelines that we practitioners often use and can be used. One guideline that I use, well, I use several, but I'll tell you about them, and I'll start with, one guideline I use is called the AAML guideline. What that is it's an acronym for the American Academy of Marital Lawyers. That is an organization, a group of individuals who are board certified and have been welcomed into the academy. And they have created a formula years ago. So one step that you might want to consider doing is running the AAML calculation. In fact, there is computer programs that can run this for you, which we have, but you can do it with your hands too and just do simple math. So the reality of that is what you do is you take the payor's income, take 30% of that. Then you take the payee's income, take 20% of that. So you take 30% minus 20% of the payee's income, that's the number. And that's gonna be on an annual basis, so then you divide it by 12, and there's a possible number. Some people think, oh, that's, not the law, I'm not gonna look at it. I do, just to kind of get an idea. Judges cannot cite to it, it is not the law, so don't argue it in court. But it is a good gauge for purposes of analysis and potentially mediation, is that formula. Another thing that I do is I look at a range. When I first started practicing, my range was much bigger. I was frankly more nervous to try to narrow the range because I was concerned what's an appropriate amount to say. I said, alimony could be 10% or 40% of your gross. Well, that's still true, but that's not the common case. You can narrow that percentage, say 20 to 30%. Again, no formula, but you kind of look at and gauge. You have to look at everything, of course, in making that determination what type of percentage it should be by going through the things I discussed earlier. Need, ability to pay, the various factors. For example, if you have one spouse who's very ill and needs tremendous care, that's going to increase their need, and the percentage doesn't matter, nor does AAML. It's a whole nother ballgame on what their need is. But different things can help you kind of gauge what alimony is. It's one of the most difficult areas because the guidelines are a little bit open, and you have a lot of people with opinions of what it should be. But really go back to, at the end of the day, need, ability to pay, the factors, and trying to be reasonable in what county you are, and what the judges or that particular judge specifically is likely to order. That's really important to think about. Be looking ahead. In the past, we did have a bill go up all the way to the governor, and it was vetoed. It had some dramatic changes to alimony. We family lawyers think that's going to happen, and perhaps this particular video snippet may become antiquated after that happens. But currently that is what the law is with alimony, but be watching for it because there's a lot of discussion what may occur with the statute and the alimony statute itself. Now again, the acronym PEACE, Parenting, Equitable Distribution, Alimony, Child Support, everything else. So today we're talking about alimony, and once a determination is made, then you can run child support. So you have to do the alimony first. Some people start running child support figures and it's an alimony case and they just run it on both parties' incomes. Can't do that yet. If you got an alimony case, you got to subtract who the payor is, what their money that they're paying, add it to the payees, then run the child support guideline worksheets. There's another very informative video on this website regarding child support that you should take a look at. But I will tell you specifically, there is a formula for child support. There is not for alimony. There's another distinction that you need to make sure that you're in tune with. Alimony is, generally speaking, you can negotiate around this if you're settling your case, but generally speaking, depending on what kind of alimony it is, alimony is either is generally taxable to the person it's being paid to, or deductible by the person who's paying it. So that is something to think about. Let me circle back to types of alimony. There's one more kind I neglected to mention I want to tell you about. That is lump sum alimony. Sometimes people want a buyout. I will give you one big amount and I'm out of here. So think about that too when you're looking at alimony. And with that, I'm out of here. Thank you.